On June 16, 2025, defendant Andrew Kosis was charged in the St. Joseph Superior Court with felony counts of theft and obstruction of justice and a misdemeanor charge of fraud. The state's case against Mr. Kosis relied on evidence that was obtained by Indiana State Police Sergeant Jeremy Bryce while extracting and reviewing data on Mr. Kosas's phone pursuant to a valid warrant. Sergeant Price reported that while reviewing the phone's contents, he inadvertently came across material that was damaging to Mr. Kosis, but also outside the scope of the warrant. Mr. Kosis moved to suppress the evidence, and Sergeant Price testified as a central witness at the suppression hearing. On January 22, 2026, Judge David Francisco denied the motion to suppress and ruled the evidence admissible. On February 9, 2026, Mr. Kosis filed a motion to dismiss for alleged due process violations. On May 1st, the matter came before Judge Francisco for an evidentiary hearing on the motion to dismiss. Mr. Kosis was represented by attorney Donald Schmidt and the state was represented by Special Prosecuting Attorney James Lutil because the defense had brought the motion and bore the burden of proof. Mr. Schmidt called Sergeant Bryce to testify on direct examination.
Sergeant Bryce, why don't we have you come on up, sir? Go ahead and pause real quickly. Raise your right hand. Do you swear or affirm under the pains and penalties for perjury that the testimony you give will be the truth, the whole truth, and nothing but the truth?
I do.
Have a seat, please. Mr. Schmidt, you can proceed, sir.
Thank you, Your Honor. Good morning, Sergeant Bryce.
Good morning.
By whom are you employed?
I'm employed with the Indiana State Police.
And since when have you been employed by the Indiana State Police?
As a sworn officer since May 1st of 2014.
How many times have you been sued in court in your life?
I've received a legal filing once, never to the point where I went to court to testify on it, but just once.
So you've been sued in court once, correct?
Yes, I don't necessarily understand exactly what you mean by that, but I have a civil suit filed against me, yes.
Let me ask it this way. How many times have you been named as a defendant in a lawsuit?
Once, as far as I know.
And was that in federal court?
Yes, it was.
And was that in a lawsuit brought by a Stephen Heckey?
Yes.
Okay. And was that lawsuit filed in March of 2023?
I received notification of it in August of 23. I don't know the exact date it was filed. A copy of this was digitally emailed to me August 11th of 2023 by our legal division.
Did you review this complaint in federal court when you received it?
I did.
Do you know whether or not an answer to that complaint was filed on your behalf in that federal court action?
I was advised at the time that I received it that our legal division would be providing defense to the attorney general, so they would be handling that civil suit on my behalf.
Doing some interrogatories or questions from the plaintiff in the case?
Yes.
And did you provide answers to those questions?
I did.
And did you sign the answers to those questions under oath?
I believe, I don't have a copy of that interrogatory form in front of me, but I believe I would have signed the bottom of that form.
Did you also review requests for documents from the plaintiff in that case that were provided to you by the state police or counsel for the state police?
There are interrogatories and there was a summary judgment declaration that I filled out, but those are the only two documents that I recall ever reviewing and responding to.
Did you get a copy of the motions for summary judgment in the federal lawsuit against you?
No.
Were you informed at some point, Sergeant Bryce, of the court's ruling on the pending summary judgment motions for which you had submitted a declaration?
No, I was not.
You were not informed?
No, the last communication I had with the Attorney General would have been in June of 2025 when I asked for a status update, and I was told that it was still pending. But up until these court proceedings, I was unaware of the outcome.
Okay. So you did have communication about the case in 2025 and specifically June of 2025, correct?
Correct.
Do you recall you gave a deposition in this case on October 27, 2025?
Correct.
Have any complaints been filed against you while you have been an Indiana State Police officer?
If we're referring to internal investigations, as I believed you had meant during deposition, then the answer is still no.
No, I didn't refer to internal investigations. My question was simply, have any complaints been filed against you while you've been an Indiana State Police officer?
Knowing what I know now, with the complaint form of the inmate being filed and that being obviously recalled to memory, then I will answer yes.
And the complaint that was filed against you in federal court was a complaint filed against you while you're an Indiana State Police officer, correct?
It was on an inmate complaint form, so yes.
And in fact, it was a complaint that led to a lawsuit in federal court, correct?
It did.
And you had to have an answer, or an answer was filed on your behalf, correct?
It was.
You had to answer interrogatories, correct?
Correct.
You had to supply documents to counsel to respond to that lawsuit, correct?
That is correct.
And you even had to supply a declaration under oath in connection with a pending legal motion in connection with that lawsuit, correct?
That is correct.
Your Honor, that's all I have for this witness.
Mr. Schmid questioned Sergeant Bryce about a federal civil lawsuit that had been filed against him, establishing that Sergeant Price had been named as a defendant in an action brought by inmate Stephen Heck on March 9, 2023. The complaint alleged that Sergeant Price had conducted a warrantless search of Mr. TC's cell phone in violation of his Fourth Amendment rights, an allegation that resembled the cell phone search issue in Mr. Kosas's own case. Sergeant Price acknowledged that he had reviewed the complaint, that an answer had been filed on his behalf, that he had answered written interrogatories under oath, and that he had submitted a sworn declaration in connection with the litigation. At a deposition for the Kosas case conducted on October 27, 2025, roughly 2 weeks before the suppression hearing, Sergeant Bryce gave sworn testimony, and when he was asked whether any complaints had been filed against him while he was an Indiana State Police officer, he answered that he had received no formal complaints. The defense's position is that this answer was false because the HEC lawsuit was itself a complaint filed against Sergeant Bryce during his service as an officer.
On October 27th of 2025, you did sit for a deposition, as you have acknowledged on direct exam. Is that correct?
Yes.
Did you testify truthfully?
I did.
Were you asked during that deposition if you had ever been sued in your capacity as a law enforcement officer?
I was not.
You answered the question about complaints, and the question was phrased, any complaints made while you've been an Indiana State Police officer? You took that to be a question.
Yes.
And your response was, no, I've had no formal complaints?
That is correct.
And how did you understand the question that Mr. Schmid posed to you?
I took it as kind of a vague question, but I perceived it to be that it was asking about any internal affairs types of investigations or inquiries to our internal affairs division, to which my answer was no formal complaints.
And have you had any formal complaints brought against you within that system as you understood the question?
No, I have not.
And why did you understand the question that way?
I don't recall exactly why. I mean, it's been a while ago, but I will say it was towards the end of the deposition. There's obviously a little bit of question fatigue that sets in eventually. I took it to mean, any complaints made. I could have, I guess, assumed, any complaints made while I've been an Indiana State Police officer could have meant, have I made any complaints, which obviously would not really make sense in the context of the deposition. And so that's why I took that as any complaints made being, have I received any, formal complaints, any complaints that would be referred to our internal affairs investigation as a pre-inquiry or a true investigation. And so I'm sure that when I arrest people and take them to jail, that they may complain the handcuffs are on too tight, or when I've taken people to written speeding tickets to them, they've shown up to court. That would be technically a complaint because they're complaining that I stopped them for speeding and they're taking it to court. But that was the context of what the deposition was, at least in my mind. And so in my mind, I took that as an internal affairs complaint and not just complaints to the degree that meant a very wide scope.
The follow-up question by Mr. Schmid, any discipline imposed, and you stated no?
That is correct.
Was that a true answer?
That That was. I believe it also kind of reaffirmed that I understood his question, at least how I took his question to mean.
What do you mean? Explain that to the court. How did the follow-up question reaffirm your understanding of the earlier question?
Anytime we have an internal investigation that does result in a founded allegation, there would be disciplinary action, whether that's verbal counseling or days off or administrative discipline. And since I'd received none of those, that kind of reaffirmed that that's what he meant was, an internal affairs type investigation.
I have no further questions, Your Honor.
Mr. Schmidt?
Thank you, Your Honor. Sergeant Bryce, can you point to the part of the question on page 51 when you were asked about whether any complaints have been made against you while an Indiana State police officer? Can you point to any part of that question that refers to internal affairs?
There is no portion.
And to be clear, you did understand the allegation that was being made by Mr. Heckey against the state police and against you specifically in the federal lawsuit, correct?
I didn't recognize it at the time, but I do recognize that it is a complaint as he filed on the inmate complaint form.
And specifically, it was a complaint, the search of his cell phone by the state police, and specifically you, was in violation of his constitutional rights, correct?
That was his complaint, yes.
And that was directed both at the Indiana State Police and at you specifically, correct?
Amongst other agencies and entities, yes.
During your deposition on October 27, 2025, in this case, you were asked a large number of questions about your search of the cell phone, correct?
Correct.
After the deposition was taken from you on October 27, 2025, you received a copy of the transcript, correct?
Yes.
And you reviewed it?
I did.
Including page 51?
Yes.
And including the question about whether any complaints had been made against you while an Indiana State police officer, correct?
Yes.
And you saw your answer, no, correct?
No formal complaints, yes.
And you didn't make any corrections to your deposition transcript, did you?
I did not.
Following the state's cross-examination of Sergeant Bryce and the defense's redirect, the testimony concluded, and the parties presented their arguments to Judge Francisco on the motion to dismiss.
All right, so it's uncontested that this was not disclosed, Mr. Schmidt. You're arguing this is a Brady violation, right?
Yes, Your Honor, in two respects. The first respect is that Sergeant Bryce gave false and inaccurate testimony at his October 27, 2025 deposition. The question that was asked of him asked whether any complaints had been filed against him while he was an Indiana State police officer. He answered no formal complaints. In fact, that was untrue. A formal complaint had been filed against him in federal court. He was well aware of it. He reviewed the complaint itself. An answer was filed on his behalf. He answered interrogatories, signed interrogatories under oath, and also submitted a declaration. So he submitted written testimony under oath in the case, and the case continued to pend through 2025. In fact, as far as Officer Bryce knew, as of today's testimony, the case was still pending, as far as he knew, on October 27, 2025. In fact, the court had granted summary judgment on qualified immunity grounds, not reaching the merits of the lawsuit, but on qualified immunity grounds a month earlier. But Sergeant Bryce wasn't aware of that. So as far as he knew, his last communication, we now know, being in June of 2025, he thought the lawsuit was still pending against him, yet he didn't disclose that. So his testimony was false. And we believe that his false testimony should have been disclosed to the defense, because less than 2 weeks later, in an evidentiary hearing, Sergeant Bryce became a critical witness for the state, so critical that his testimony and his name was referenced 25 times in Your Honor's order deciding the motion. He was a central witness because it was plain from the evidence submitted at the evidentiary hearing that materials outside the initial cell phone search warrant were reviewed and seen by the state police. The state defended on the ground that Sergeant Bryce had seen this in plain view, that he'd come across it inadvertently as he was starting to review the material on November 8, 2024. His credibility, his testimony was critical, and the defense at the November 7, 2025 hearing was completely denied the opportunity to cross-examine him on the ground that he had given false testimony in his deposition. The state police, and specifically Investigator Bryce, knew that his testimony was false and that he had in fact been sued in connection with what was alleged to have been an illegal search of a defendant's cell phone. Very similar allegation to what has been alleged in this case in the defense motion to suppress. We believe that these Brady violations were obvious and egregious. They were material. Impeachment of a key witness in a matter is always material. The state suppressed the evidence, another requirement for a Brady violation, because it didn't disclose the evidence to us regarding the Heckey lawsuit or the false testimony of Sergeant Bryce at the deposition on October 27, 2025. The material was clearly exculpatory in the sense that it would have provided powerful impeachment evidence of Sergeant Bryce if we had been properly made aware of it prior to November 7, 2025. We were not made aware of it, as was the state's obligation. There is no more fundamental rule in criminal law than the state's obligation to turn over exculpatory and impeachment evidence, and we were denied the opportunity to effectively cross-examine Sergeant Bryce in the evidentiary hearing in this case. Because of the egregious Brady violations, Your Honor, we believe that it's appropriate to dismiss the remainder of this criminal case